Welcome back to Lost Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to look at a Supreme Court case that answers the question whether police can search and even take your garbage that you leave outside of your home for trash collection. And before we go on, I want to thank you for watching me on YouTube and hitting that subscribe button. And if you're tired of getting garbage gifts for Christmas and other holidays, consider asking your mom to go to lostash.com and buying you a Do Not Arrest This Person t-shirt. And if your mom becomes a member of this channel, she can click the join button on the main page on YouTube, and for a nominal fee, she will receive 15% off all the products on my website. Thank you for watching, thank you for subscribing, sharing my channel with your friends and family, and if you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. Let's go on.
Quick message from Lostash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lostash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lostash YouTube page. That's Lawstache.
Like I mentioned in the introduction, today we're discussing a Supreme Court case, California versus Greenwood. When I look back at my channel, it turns out I have nearly 300 cases that I've previously discussed. And of course, all of these videos are archived and you can easily go back and watch them. But I was surprised to learn that I still haven't discussed this case with you. After all, this is a landmark decision by the Supreme Court, and of course you already know that it deals with trash collection. Let me give you some factual background. Officers obtained information from neighbors that Mr. Greenwood might have been trafficking narcotics. Essentially, the tip said that there was a lot of heavy traffic coming in and out of the house. Cars would park outside of Greenwood's home for just a few minutes and leave every day. So officers began to surveil Mr. Greenwood's home, and they essentially saw the same thing. At some point, one of the officers made a decision to ask a regular trash collector that goes and collects trash throughout the neighborhood to pick up trash from Mr. Greenwood, take the bags, but don't mix them with other houses. Instead, take those bags, don't put them in the truck, and give them straight to the police. Officers then took the bags, searched inside, and found evidence of narcotic use. With that information in hand, officers then obtained a warrant to search Mr. Greenwood's house. When they executed the warrant, they found narcotics in the house and ultimately charged Mr. Greenwood with felony drug possession and distribution. Mr. Greenwood was able to get bail, and during the next weeks, officers once again asked the trash collector to take the trash. They once again searched that trash, found more evidence of narcotic use, obtained another warrant for the house, and found more narcotics. And once again, he was now charged with even more felony counts of drug narcotic possession and distribution. Mr. Greenwood argues for the suppression of the evidence found. He says that the officers were never permitted to search the trash, and only with that information they were able to obtain the warrant for his house. Something to remember. The Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before conducting a search. But of course, there are exceptions to the rule, and in this case, we actually don't have to go into the exceptions, because before we can say that a search is deemed unreasonable under the Fourth Amendment, we have to determine whether the Fourth Amendment even protects the individual. The warrantless search and seizure of the garbage bags left at the curb outside the Greenwood house would violate the Fourth Amendment only if respondents manifested a subjective expectation of privacy in their garbage that society accepts as objectively reasonable. Greenwood asserts that he had a subjective expectation of privacy. He says that the trash was left at the curb at a fixed time. He placed his trash inside an opaque bag, this way no one else can see inside. He then expected a trash collector to take the bag, mingle it with other trash from the neighborhood, and then deposit it at the dump. He says that the trash was left on the street for just a short period of time until the collector would pick it up, and he did not expect anyone else to look through his bags. But what about the objective expectation of privacy? The Supreme Court says that here we conclude that the respondents exposed their garbage to the public sufficiently to defeat their claim to Fourth Amendment protection. It is common knowledge that plastic garbage bags left on or at the side of a public street are readily accessible to animals, children, scavengers, snoops, and other members of the public. Moreover, respondents place their refuse at the curb for the express purpose of conveying it to a third party, the trash collector, who might himself have sorted through respondents' trash or permitted others, such as the police, to do so. Accordingly, having deposited their garbage in an area particularly suited for public inspection and, in a matter of speaking, public consumption, for the express purpose of having strangers take it, respondents could have no reasonable expectation of privacy in the inculpatory items that they discarded. Further, the courts have expressed the idea that we can't reasonably expect the police to avert their eyes from criminal activity that other members of the public can readily see. So here, because other members of the public could have looked through the garbage, the police are allowed to do the same. So what are the major takeaways from this case? There's one major takeaway in this case. The Fourth Amendment does not prohibit a warrantless search and seizure of the garbage that you leave outside the curtilage of your home. I hope you learned something in this video. If you enjoyed it, please give it a thumbs up. Please subscribe to my channel and share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, and if you're thinking of buying somebody a gift, consider going to loststash.com and purchase the Do Not Arrest This Person t-shirt. I promise they'll love it. Thanks for watching.